use it to always train your brain when you feel uko na brain clog. So put one hand on top of your head and the other on your stomach. So this is what you do. Yeah. Yeah, nice. You're just rewiring your brain. Okay, we can do another one. This is called crisscross. It helps you align your left brain and your right brain. Yeah. Nice. Nice. Ah. Do a little bit of exercise, eh? Jinyoshe kidogo mazee. Nice. And then pia guest wetu akikuja tunaweza kusema pepe pepe. Can I get a pepe pepe? Pepe pepe. Yes? For the mood. The lights ziko okay hivyo? Ziko okay? Oh, fantastic. So let's appreciate our guest as she takes the stage. Wow. See,
Hi,
how are you doing?
I'm well. First off, I really apologize. Honestly, there's no excuse, so I apologize vehemently for wasting your time. Don't worry.
we believe your time is very valuable, and even if you've come at this time, whatever you're gonna give us is gonna change our life forever. And I'd love to teach you one word: causation. Causation means when those when those activities, how do you call those phenomenal activities? Yeah, when a phenomenal activity occurs and it contributes to another phenomenal activity to occur. So the reason why I'm stating this is when we first met, we met in a coincidence that hiyo wiki tuko napanga, me and my friends, on the events that we can go to. So aka introduce something inaitwa Luma, where you do check events online, and kuna event iHub. From where I stay to iHub is a walking distance. Tukasema this event we have to go because there's no fare tunalipa. And that's how I met Mercy. She was talking whatever she's gonna talk to on today on IP. And before we start, I'll just ask, before you got into courtrooms, what your background story, like when you were a kid, what activity occurred in your life that led to you being in a courtroom?
First off, I never thought that I'll be in a courtroom. I usually used to say, because I used to be that Christian girl who used to go to CU. I used to say that lawyers go to hell. There's a verse, I think, which says that somewhere.
All right.
So I knew that I will not be a lawyer. But being an IP and tech lawyer was some sort of escape from the traditional courtroom type of lawyer. So what I do is IP tech, media, telecommunications, and a bit of commercial. That's how I got into that, just to escape the traditional criminal sects of law. I didn't want to deal with it.
All right, traditional criminal sect of law. All right, okay. And one of my first question I'll ask, how good is an idea to be protected?
It depends with the type of idea. Well, are we looking at a new invention? Are we looking at the expression of an idea, which will be a copyright? Are we looking at the protection of a brand? It depends with what you want to protect. Maybe we can look at the, is it okay if I look at the audience?
Yes.
Who has an IP idea which they want to protect? Who? Anyone? Anyone? We can just pinpoint it, yeah? Based on that, you can tell that this is a protectable idea. You can tell that this is an idea which is new, which is inventive, and which is industrially applicable from what you've said. Obviously, that will, it will, what's the word? It will qualify for protection just because it's new, it's inventive, and it's industrially applicable. Secondly, for the AI system you have, I'm sure there's a readable format. That readable format can be protected as a copyright. So those two are applicable to idea. That's how you identify how an idea can be commercially viable. If it's not commercially viable, in my opinion, not that it will remain under the bed or in the boxes, but maybe work on it a bit more and then produce it to the world, obviously after protection.
Okay. Just the other day I was in the matatu and I was listening to the radio that Hurricanes and furthermore, they had got a court restraint from BMR to not strike their content. So this question is, at what point in someone's stage is he supposed to be keen on what ownership they give out there?
Thank you for that. I usually say before you enter any room, make sure that you've registered whatever you're putting out to the world. So whenever you have an idea, whenever you have a creative work which you want to put out to the public, make sure that it's protected. The only way it can be protected is if it is registered. For instance, any artists who's out there, whenever you want to put out, let's say a song, but in this instance, really, songs are protected without even protection. But generally, whenever you want to put out anything, let's say the AI system which you were given for, I hope you've not released it, and if you have, I hope it's registered. That's the only way you are going to protect it. So back to the question, when should it be?
Yes. At what point should it be protected?
At what point? At inception, before release to the market. Sometimes you may have to include investors. Make sure even before you include investors or funders, make sure the very least you've done is to have it registered. Once it's registered, obviously, you'll be the evidence that you are the one who authored that invention.
We are living at a stage where everybody is starting a business. Everybody is starting something new, and everybody is bringing people together to work together. And my question is at which level of collaboration should a formal contract be provided, especially to people you're bringing on board to your work?
If you have a team, when you're bringing people on board, I'd think you're bringing them in two levels, maybe a funder or an employee.
Right.
So maybe we can deal maybe with the funder first. If you're dealing with someone who's supposed to fund your project, obviously, still the AI project, you have this new invention. So even before you bring them in, obviously you'll have to reveal the inception of what the idea you have. Before you reveal it, one of the things you'll have to look at is an NDA. You'll have to sign an NDA with every party in the room which you are entering. Secondly, if these are funders who want a stake in your business, you should make sure that you have a shareholders agreement. The shareholders agreement will show specifically the details of every shareholder, including the funders, the decision making, and even the termination of the contract. Now, when we're looking at employees, when you're bringing in employees, we're looking at whether you're dealing with an actual employee or a contractor. When you're dealing with an employee, the obligations change. Under the Employment Act of 2007, an employee is determined when an employer determines their working hours, the environment by which they work. And from this, there are statutory rights which are accrued, including the annual leave, the remittance of NSSF and NHIF. From this, these are the things you're supposed to consider when you're bringing in someone. When it's a contractor, basically, this is a free molecule. They can do whatever they want. So the only thing which will be taxed with doing is withdrawing the withdrawal, is deducting the withdrawal tax, which is taxed at 20%. That's the only thing you'll have to deal with when you're dealing with a contractor. So it's twofold. When you're bringing in people, when it's either an employee, you should consider that the statutory duties which you have to the as an employer, you should consider that the statutory duties you have to the employee are fulfilled. As a contractor, make sure that the withdrawal tax is remitted. As a If a funder is coming
Founder.
to your business, make sure that these shareholders agreements, NDAs, every other agreement which will be applicable is also put in place.
Just on that question again, because we're living, for example, this community is a community of people who are building startups.
Yeah.
And you find out, I've started something with my friend, we didn't have an agreement, we fall out, then a few months, the startup that we started, the idea that we started is also growing. Okay, to this environment, most of the people that are here don't have agreements with the people they are working with. And what might happen to such kind of situation when you find yourself in a situation where your startup, your idea blew, but you're not in that room at that given point when it's doing well?
Whenever you find yourself in a situation where you do that mini audit and you realize that you don't have any agreement in place in your working, you know, automatically you are setting yourself up for disputes. For instance, you and your friend, obviously you started this business as friends. It was not commercially viable at the moment. You were working up. Maybe he came up with the funds, you came up with the skills, or maybe the two of you contributed the skill and funding equally. But then you see, this friendship is not something that will be there for the next 2 decades. Not to be pessimistic, maybe it will be there. But the foundational bit is whenever there's a falling out, someone somewhere will come and say, I gave 80% and you gave 20. So when it is commercially viable, the profits may be divided at 80-20. The only way to evade this is by having an agreement. The agreement sets forth the terms from the onset. For instance, if you and your friend decide that you're going to have a 50-50, when the company blows up in the next decade, it's still a 50-50. Nothing will amend that. Secondly, whenever you have disputes, it's specifically indicated on termination, I retain ownership of this company. Or if it comes to decision making and you want to give a stake to someone else, obviously the person with the larger stake has a higher voting capability, or even the chairperson of the company has a casting vote, meaning where there's a tie, the chairman has the vote to oust the other votes. So those are the things you look at when you're coming up with an agreement, and this agreement is what will evade every other dispute and protect you from the beginning, not from the beginning.
All right. Hope mnamsikia. Yes, we are building up companies each and every day without agreements. We are bringing up ideas together without proper understanding of each other. So my next question is, what are the most common contracts mistakes creatives make when working with brands, agencies, or collaborators?
The one that comes at the top of my head is not reading the contract.
Oh.
Yeah, like you're getting a contract and you're told this is the standard agreement, this is what we give every other creator, and you're looking at clause 3 and you're like, what is this? I don't understand this clause. You'd rather not sign that contract and text that wakili friend of yours and ask them, in due regard, what does that mean? In limited to, what does that mean? When used in this context, what does this mean? Ask. It's the only way you elevate some of these things. You may bind your creative works for a lifetime just by not understanding one word in the clause. The second thing I will think of when you're looking at a brand, ask the when, how, what, and where. Like the when is this stopping? When are we starting? Will I have to do this in the next 6 years? Will I do this for 3 months? Where are we doing this just in Kenya? Will this be limited in Kenya? Will this brand use my content across Africa? The what am I giving out to this brand? Will it be my literary works in the name of in the form of maybe poems, books? Will it be my artistic works, like whatever is on the backdrop? Yeah, how understand how you are supposed to deliver this content. We've seen instances where creators have lost brand deals just because of the how. because you are specifically told that you are supposed to do a video. Decided to do a video, add music which is copyrighted. Guess who's paying for the infringement claim? You.
Okay, not the client.
No, it's you, because you are the one who breached the contract. If you that's why I was saying you should read the contract. Whenever you breach such things, and the contract specifically says that in case of damages, you are personally liable. It's you. It's on you to pay.
Okay, and to instances where your work or your creative work has been used for somebody else who has benefited highly from it, you guys didn't have an agreement, a contract. Just from the case I did raise last time we were together, I've worked with this lady for a while, and she uses our images to benefit her product. Right now she has opened more than 10 stores across the country, and she does sales even to China. So, like, for instance, we never had an agreement with her while we were doing for her the product shoots.
Actually, the fact that you didn't have an agreement is a good thing for you. Just because they cannot show that you gave consent for them to use your image. So we go back to the original format, which would be my copyrighted work cannot be used without my authorization. So where is the authorization if there's no agreement?
Okay, where is the authorization?
Yeah.
Wow.
So in that instance, it's good that you do not have a contract. But in other instances, especially on inception, make sure you have the agreement. I'm sure if you had the agreement, I don't think she will do what she's doing right now. You can just issue a quick cease and desist letter, like a quick one. Tell them to bring it down or pay you for. Actually, there won't be a point for asking them to bring it down. Let it stay there, and then they pay you for the royalties of using your image. You'll get money from that.
I may count myself a millionaire soon for that. Yes. When you're signing up a contract, what should every creator know before they sign anything?
When you're signing a contract, when you're a creator, obviously you are licensing a bit of your work to a certain person. So know the limits of this license. Will it be exclusive or will it be non-exclusive? By exclusive, will it mean that you're giving it to one person? Or non-exclusive, will it mean that this person you're giving it to will sublet it to other people? Be very certain about that. The second thing you would look at is I think it's the same question you asked me before. Yeah. The when, what. Same thing. Also look at the cancellation clause. By the cancellation clause, they're usually projects which run for 2 years, 3 years. So when a brand decides to cancel after 6 months, what happens? You're supposed to get money for those 6 months. Make sure that even if they cancel quarterly, at least you'll get paid for whatever you've already done. The third thing, obviously, termination. Termination usually causes a lot of issues. Make sure that you know that if the brand goes insolvent, they cannot pay their debts, our deal is off. If you take my, let's say, copyrighted work and my moral rights and use them in a derogatory way, then the deal is off. Look at such things. Everyone has a negotiable bit. There are things which you may not want your contact to be associated with. So be very particular about that. If you may not want it to be on certain websites. We've seen some advertisement on some questionable platforms. Be very specific. That you do not want your works to be listed in certain platforms, especially, I know you get me, right?
Nice one. I'll just take you back. Already you're a founder, you've built a team, and the business has grown. So what are some of the structures that a founder should always be prepared while the business is growing? Something that some of the things that he or she should keep at note while the company is growing, so that he can be able to change the contract that is already existent with the people that they're working with.
The first thing I'm thinking of, if you're a founder and you're skilled enough, the first thing I'm thinking of is, if you are a sole proprietor, it's very advisable to switch it up to being corporate, in the sense that you should set up a company. The reason for this, if you are sole proprietor, you are personally liable for everything. So if debt comes to you, if these damages come to you, you're personally liable. You'll pay with your own money. But if there's a corporate entity which is separate from you, the company will be liable for the debts incurred by the company. So the debts will stop at the company property. They will not intrude to your property. Obviously, there's an exception for that, especially in fraud cases, whereby they lift the veil and come for the individual founder or director. But in most instances, it stops at where the company property ends. The second thing I can think of is, as a founder, this is a room of creators, right? Make sure that whatever you're putting out to the world is protected. Make sure that it's registered. Secondly, make sure you have the appropriate agreements in force whenever you're dealing with any party. For instance, when I'm dealing with a author here, and I have this nice idea, then I'm too excited, and when we're speaking, I'm like, oh, I came up with this thing. You can do this 1, 2, 3, and then tomorrow I see you go to the same product. What happens? Such things. Sometimes it's all about also. I think you've seen the case of Pitante versus Safaricom. You've seen it?
Yeah.
Yeah, sometimes I looked at that case, and to me it felt like a case of restraint. Sometimes you're really excited with an idea, but take a step back, look for someone who's actually knowledgeable in this. Ask them, if I go to Safaricom with this, what will they do with this? And you know what Safaricom usually does with such? We not speak, they may be my future employers. Yeah, but be very intentional with what you want to protect. Guard it with everything you have. Because ideally, once an idea is gone, it's gone. There's reverse engineering. Even if you put the product out there, someone somewhere will take it and work their way backwards and get back to whatever algorithms or whatever you used. That's the beauty and sadness of it all.
All right. Yes. Oh, nice. So there's this thing that I'm always in town, and I see these photographers in town. They've been given free permit to take content and take photos in the streets of Nairobi. What are the future challenges or court problems that these people might face, or is there a challenge that the government is not seeing, giving permits without a written agreement to these street photographers in town or the content creators in town?
Well, when I'm thinking about those people, they get express consent, right, before they take the pictures, or they just take them randomly. Honestly, I'm asking from a point of delusion. I'm not sure.
Wait, picha, utapigwa picha. That's how they
Okay.
do it.
I mean, if you agree, that's on you because you gave consent. But if they take unfortunately, in Kenya right now, the Copyright Act Cap 130 does not delve into imagery rights. So whatever, like the Netherlands, the picture, the facial features of your face, they are subject to copyright. But in Kenya, it's not yet. We are not yet there. But now, based on that, we'll have to switch it to data protection.
Okay.
Data protection protects your personal data. And as per Section 2, facial features fall under personal data. So whenever they take a picture of you, I'm sure you saw the Carrefour case, whereby they took a picture of the customer, and the customer sued them, and they had to pay good money.
All right.
Yeah, so whenever someone takes a picture of you and uses it, especially commercially, they're supposed to pay you. For these people, where do they place the pictures? Are you sure it's not Juju or something? Where do they take them?
If you don't pay, they'll just retain them in their.
But I'm not sure. I'm not sure.
Okay.
But obviously, there's the data protection bit of it. Whatever is taken from you without consent violates your right of privacy as per Article 31 of the Constitution. So
securing securing patent, IP. And one of the problems that I do think we go through is we don't know the process, we don't know where to go, we don't know where to start. So my question is, intellectual property registration, what is the process, the cost, and what does a creative in Kenya actually need to register?
So for creatives, what I'm thinking of is basically trademarks and copyrights. Should we go to patents?
It's open.
I
Should we go to
don't think.
patents?
Yeah, according to, because of him, we may have to go to patents. So where do we start? Let's go with trademarks first. So trademarks are protected under the Trademarks Act, Cap 546. So whenever you want to register a trademark, you go to KIPI. It's the Kenya Industrial Property Institute, Papa Westi. There's usually an official fee which is usually paid. The filing fee is 30-50. I don't know if I say classes, will you understand? So whenever you're filing a trademark is filed within a class. So a class, for instance, when I want to register, this is very hypothetical, this cannot qualify as a trademark. Let's say pharmacy, and I want to register that trademark with regards to medicine. Medicine relates to class 5. So I'll go to KIPI, take my trademark, register it under class 5. So that will amount to 30-50. Whenever I'm adding a class to it, let's say if I want to do entertainment services under the word pharmacy, I'll add class 45. So it will be class 5 and 45. That will be 30-50 and 20-50. So the first thing will be to file. It will go through the examination process. So whenever it's going through the examination process, the registry determines whether this trademark is similar to any other trademark on the register, or even if it's contrary to maybe public morality. Obviously, there are words which may not be accepted. There's a trademark I saw another day. It was called Devilish Energizer. It was refused for obvious reasons. Yeah, so after examination, it moves to publication. The purpose of publication is to inform the public that this trademark is about to be registered. So if there's anyone in the public who wants to oppose this trademark, they will do so within 60 days. From that, it will be registered, and an hard copy certificate will be issued. So the whole process is around 20K, depending on, there's a bit of technicality there, which you may approach me, you may attend, because I can't go to them. The second one would be, maybe let's go to patents. So patents are still registered in KIPI. Patents are subject to the Industrial Property Act, Cap 549. So when you're looking at a patent, the first thing you should determine is whether your patent is new, whether it's industrially applicable, and whether it's inventive. If it fails any of these 3 requirements, it will not be registered. So obviously, the first thing is filing, examination still, publication, and then registration. The same is with the utility models. I feel like I should have come with like a PPT, because I can already tell nimepoteza watu. But yeah, from patents, it's the same as a utility model. Who knows what a utility model is? Anyone? So yeah.
The process of the utility model, with the process of how you're coming up with the product.
You're partially right. So the utility model is like mtoto wa patent. Whenever you see that your patent does not meet the threshold, the 3-point threshold of being new, inventive, or it's not industrially applicable, you may revert to a utility model. The bad bit of registering a utility model is it's viable for only 10 years. Patents are viable for 20 years. So that's the only discrepancy. Also, yeah, that's about it. Then, we can move to copyrights.
Yeah,
There's so many. Will we really finish this?
copyright.
Copyrights are registered under KECOBO, the Kenya Copyright Board. So copyrights, there's the filing is done online on the KECOBO website. You log in, upload your details, make sure that you are the works which you want to be registered as a copyright can be placed in a fixable format. If it's a song, I'm sure there's a way it's usually put forth. If it's the AI system, there's a way you can place the algorithm or the LLM. I don't know what it was. Because you know that the Peter and case, whatever helped him was he had the invention registered in 2019. So whenever when Safaricom came up with this invention in 2021, like you can see the difference. You can see who actually created this thing.
So is it like registered as a business, or it's just an idea registered?
The idea registered. So in his case, a patent. In your case, it will be
It's just hypothetical.
okay.
Tangible.
Yeah. Yeah, I hope I'm not. Yeah, okay.
Any questions? All right.
Thank you. Hi.
Hi.
My name is Blessed, and I'm also a tech lawyer actually. I do TMT, IP, and all that. So my question is, but today I'm here actually. My question is, in this age of AI, let's say I've used a little bit of AI in my designs. How do I protect this? Is it protectable? And how do I differentiate my work with my work in AI? Or like how do I protect something that I've used AI as a tool?
I think my first question to you in response to that, which is not a good way of answering questions, but which type of idea are you protecting?
Okay, I do graphics design, so I design a lot of things digital. Using tech. So it would be probably a digital painting or a digital artistic work. Yeah.
So that's copyright as per Section 2 of the Copyright Act. So in that case, I'm sure you're aware that as per the Copyright Act as is, Section 26 specifically denotes human authorship when it comes to copyright. So whenever you've used AI, even if it facilitated you to some specific extent, make sure that the overall authorship is with you. That's the only way you can protect it. Also know that when you're looking at copyrights, it's protected on creation, not on registration. The only reason that it's registered is so that there's evidence of the fact that this copyright was created. So when it comes to AI, how can you protect yourself? Well, when you're dealing with copyrights, I won't even lie. You've read the copyrights bill. Yeah. There's really no mention of protection of. There's really no mention. So we maybe we can look at the common law, because we can look at cases like Getty Images. You see how Getty Images flipped whatever was being done to them. So I think it was GPT which was trying to chat GPT, which was using the data sets from Getty Images. So the only thing which caught up to them was that whatever was generated had the watermark. So my first point would be, whenever you want to protect your works against AI or anything, have some form of digital identifier that even if they try to train AI with or remove or something, there's always that identifier there. It's the Getty Images case. The second thing I can think of would be for people who use the free version of so obviously we know that whatever you're giving out is being used to train these models. So even if you're giving them sorry?
You can turn it off even if it's free. There's a setting, especially for Claude, that I'm sure you can turn it off and say, do not use my data to train the AI models. That I'm sure. However, there is the other aspect which I had. If you're still going to use the free versions to generate, whether it's content or anything, it's not really yours.
Yes. So whenever you feed it your creative work, obviously it goes into the system. It goes into the data center. It may be reproduced 30 miles from your actual location. It is what it is. It's the same way when you're looking at logos and you're trying to replicate logos. 80% of the time, you'll find that whatever has been generated under whatever you have. Just go and search. You'll see there's something similar on the net. That's usually the tricky bit when dealing with AI. We are still catching up. The law is catching up. We may catch up, but the truth of the matter is, even when you're looking at the Industrial Revolution, the law came after the Industrial Revolution. So obviously, AI will come and then the law will play catch up. Unfortunately, in Africa, we are playing more catch up. So it may take more time. Yeah.
My final question would be, if I do a painting, a physical painting, but it's more of I'm painting something I'm seeing, is that really an original work that is worth being copyrighted, or it's not original?
Yes, it is. When you're looking at the definition of what a copyright is an original work, something which you've created from. Obviously, even if you're looking at something, your interpretation of whatever you're looking at and my interpretation will be different. So it doesn't have to be new. Copyrights are the only form of IP which do not protect the new bit of it. It protects the original bit of it. So whatever you, sorry?
The expression.
Yeah, the expression of what the idea, not the idea itself, the expression of the idea. So ideally, that would be a copyright. Whatever you paint is yours. Yes, yes. Oh, it's a follow-up. Let me deal with this first. I'm thinking about that question because when you start, obviously they'll come for your neck, obviously. But then they were on the wrong in the first place. But you see, law is very equitable. You cannot take whatever you actually gave and say that, like, a wrong does not make a wrong right. So how, in my opinion, best case scenario would be just to go to court, because either way, even if you start as a competitor, can you match up to whatever they're doing?
Yeah, maybe I've found other investors who are willing to help me.
The thing with the investors is they won't invest in whatever is already in the market. And investors only invest in certainty. They never look at an idea and be like, okay, this is nice, we can also do this. Because they know, also, brands really value their reputation. Anything that tarnishes their reputation is a no for them. That's why even when you're looking at the Pitantei case, you can see how they really tried to bring the CBK and Huawei into that car agreement. I'm sure they were trying to salvage everything, something there, but the story did not add up. That was the only issue.
Sorry, just a follow up on that. I think also, in my opinion, you would be giving away your rights essentially, and you'll still somehow end up in court later on, because these are two identical products, and now you'll be fighting about who came up with it first. Yeah, so it would really be better to just sue them, because now you have actual evidence, you have an NDA, and they breached the NDA. But if you let it run, itakuwa ngumu huko mbele.
The other thing would be, when you're looking at this NDA, make sure that this NDA is actually signed. There's this case, Popote Innovations, still against Safaricom. These guys had an agreement. The agreement was sent to them. The transaction was complete, and when Safaricom decided to backpedal, they look at the agreement, and Safaricom were like, "We're not aware of this. We never signed this." Yeah, and they lost billions. Was it millions? It was actually millions. Popote Innovations. So whenever you're looking at this agreement, make sure it's properly executed. Otherwise, it's just a piece of paper somewhere, just words which are not signed and agreed upon. I think you had a question.
Thank you so much for the floor. Actually, my question comes from such an instance where, say, you're an employee for, let's say, LX, but then, yeah, there's that NDA agreement between the employer and the employee, but then she stated that, let's say, LX moved on ahead to implement the idea, but I do believe there is more or less like a non-compete clause. So if there is that breach where the employer goes on ahead to initiate her interest, would she be more lenient, or will she be okay if she breaches the non-compete that has been in agreement between the two of them?
I'll answer this by looking at where the relationship between the employer and the employee started. When you are given the contract, there's usually a clause 8, 9, 10 somewhere on intellectual property, which bequeaths all intellectual property created in the course of employment to the employer. If there's that, if you move to another place, they'll come for you and take damages. Even if you go and give that idea to another person, they'll still come for you. There's this case of Bratz versus Barbie, the Barbie dolls. So this guy moved from the Barbie dolls, went with the idea, started the Bratz dolls. Obviously, the case took a bit of time, but at the end of it all, the creative director still had to pay Barbie because of moving with the idea. And obviously an idea is protected as a trade secret. To note, trade secrets are not registered. Trade secrets are protected as long as they remain as a secret and they remain commercially viable. So as soon as this creative director moved from Barbie to Bratz, obviously they moved with the bank of the money which belonged to Baki. To Barbie. Man, these words. Baki, Barbie. Yeah, I hope I've answered you.
Yeah, I get it. Thank you.
Mine is still on the aspect of the moving to, let's say, another company with the same idea. So if, let's say, they're not ready to what's the word, compensate you for that invention, right? Then you go to another company, then implement the idea. So I think you've said they will come for you, but what if, like, let's say, okay, in my position, I know this aspect of maybe you'll be asked what you are arrogant not to read the contract. But what if the HR themselves didn't give you the company policies and everything? Is it my mandate to go and ask for it to review it, or again it was the process of hiring, right? They should have given you all this during the hiring process, because I'm asking the perspective of I've never seen the policies, so even the inclusive of the IP.
There's usually that saying that the law favors the diligent. Like, you cannot come and say that, oh, I did not read clause 3. This is not what I wanted to say. There's is it a principle? It's called the parole principle. The parole principle states that whenever there's something which is in written, cannot come back and say in the form of word of mouth that I was not aware. It was upon you to go and search and find it. The second thing would be they look at, did you have the capacity to understand this and obtain this? Is your level of English at a certain peak that you can look at this and understand it? If it were at a place where you could not understand it, obviously you did not have the capacity to sign it. If it was in let's say Spanish, and you don't speak Spanish, obviously you'll read a translator, you'll read the translated document. What else would I look at? The only other thing I could think of is if you are below 18, which will need a guardian, but it's an employment contract. Obviously, you're above 18.
Wow, the future of court cases is here with us, and we're already handling them. Just to wind up on my questions, just on IP licenses and royalty payment, how does a creative structure license agreements so their work keeps paying them over and over? And what are the key terms every creator must understand before licensing anything?
So that your idea keeps paying you over and over. There are 3 ways you can structure your royalty payments. You may have them as a percentage of the sale, or you may have it as at a prorated rate, or you may just pay a big lump sum amount even before putting out the product in the market. So depending on your type of work, I think you'll pick within the three, between the three, among the three. It's among the three. When you're looking at the clauses to look at,
The terms every creator must understand before licensing anything.
the terms you should look at the territory by which you will be dealing with. If it's Kenya, there's some countries which do not allow some type of content. You'll also have to look at the cancellation clause. What would cause the contract to be deemed void? What else would you look at? You look at the duties. What are your duties in the contract? What are the duties of the brand which is contracting you? The third will be, I'd mentioned the cancellation clause. Whenever you have a project and you've done a bit of work, and then make sure that whatever you've done in the project is already paid for. Also, you should have a termination clause whenever payment is not effected. The termination obviously will, there are usually things which are copy pasted in every contract: bankruptcy, death, solvency, insanity, those type of things. Basically, it's just like any other contract. Just get yourself a good IP lawyer, and people won't steal your ideas.
I think you've seen a good IP lawyer, yeah. All right. I think I'll ask you this question. We're in an age where information is being accessed by AI, through AI, and people are actually neglecting the responsibility of having a lawyer, and then they're just depending on AI. So what are the future problems these people gonna are the people who are relying on AI for most of their problems to be solved? What are the future problems are they going to encounter?
The first one I'm thinking of is because I've dealt with recently are AI generated images. So whenever a client asks you to generate something as a graphic designer, kimbia pale, I don't know where, then generate stuff. Don't cross check on the internet if there's something similar. Then your client goes and files it as a trademark and it's refused. You know, that's money. There's money which has already been expended there. There's branding which has already been done. There's advertising which has already been done. Who pays for that? You see? The second thing I'll think of is AI with regards to copyrights. When you're looking at copyrights, it's a bit here. I don't know. The law itself is not as expansive as I wish it to be. It does not even show or even provide for what is it called, the training of AI data sets. It does not provide for that, and that's a major thing. We've seen so many cases right now in the US and UK because of the training of data. The other thing, even when I'm looking at AI, like suing, territorial suing, cross territorial suing is very expensive. Like, how would you expect a founder whose content has been copyrighted, has been infringed on in Kenya, to sue someone in the US? We already have a gap of around 29 per shilling. So how are we going to fix the suing bit? Also, how will you get counsel over there who will work on pro bono? No one will work with that. The third thing I'd think of, or am I at the fourth thing? When I was looking at the Getty Images case, one of the reasons why that case failed was because in that specific case, the data centers were not located in the UK. The data centers were located in the US. So the defense was like, this data isn't here anyway. So the jurisdiction obviously is not in the UK. We're supposed to sue in the US. So you see, like me as a founder or how do you ascertain that? You see, there's a gray area in AI, especially when it comes to intellectual property, which we've not yet understood, or even we've not gotten to a point where we can play catch up with it. But regardless, with whatever we have, Yeah, that is my answer. Honestly, when it comes to AI, there's a lot with regards to intellectual property.
Okay.
It's just harder than it's supposed to be.
All right. I think this will be my last question. Okay, you have a team, and also maybe your co-founder wants to leave. Wants to leave your team. What should they present to the team if they did sign an agreement being part of the team?
What should they present to the team?
Yes.
Every document they have with regards to that document should be remitted back to the company. Obviously, that's in the agreement itself. Whenever you leave, you bequeath everything which is not yours to the company, because all property belongs to the company, doesn't belong to any individual. Secondly, whatever profits they have, obviously they'll go with them. But even if they go and incur debt, and within that year they were there when they incurred debt, you are liable for that debt. So they should pay for that debt. Thirdly, what should they give to the company? I'm sure there was a non-compete clause. So whatever they go non-compete clause, so they cannot go forth and set up a competitive another company which will act as a competitor. If that was a good contract, if it was generated by ChatGPT, well, that's all I can think of right now.
That's very nice. Thank you.
Right, I wanted to ask, above all, if you copyright or trademark, what are the benefits that the creators, creative creators, are going to get from all this process? If you decided to patent your idea or you decided to trademark your brand, what are the benefits of this, all in all?
Thanks for that. When you're looking at a copyright, the benefit is let me start. Overall, the benefit is that it will be yours. That's the number one benefit. The second thing is, if we're looking for investors, no investor will invest in something which is not protectable. They'll have to get a guarantee that whatever they are putting their money into will not be taken up by another person. The only way you can guarantee that is through registration. The third thing would be whenever you'd want to, maybe in future, to license it or to give your product out to any other person, or to even sell it to another person, the protection which you already have would be the basis that this is my asset, this is my brand. Whatever I'm selling to you is my assurity, and it's my confirmation that it's protected. The fourth thing I'd think of is just aware of competitors. There are some competitors who just scrum out just because you've registered. There are some who are, people are becoming a bit more bold. But above all, even if you have this intellectual property,
Loyalty test. Like, he came with the idea, started it, then all of a sudden everyone was doing the loyalty test. Do you think if he would have like copyrighted or trademarked it, will he be kind of safe from being exploited? Because he brought the idea, but we've seen other people doing it all around.
the first thing I will think of is, let's go back to the definition of a copyright. A copyright is the protection or the expression of an idea which is original and can be in a fixated format. So let's underline original. So let's look at this loyalty test. I've been seeing them since I was 5 years old and I was born in the 90s. So yeah, I think that's my answer. Really, like, there's nothing you can. Okay, the best thing he will protect is just the name of the brand, not the word, the loyalty test, but the Pluto brand. But the loyalty, I think we've seen it in different forms. It's the same way we've seen the balloon. It's everywhere. It's literally everywhere right now. The keyword, it must be original.
Okay. Also, I've heard of Wekamawe being patent. I don't know if you've heard of that.
It's a part. What's that though?
Wekamawe.
It's like a slang.
Oh, that's a trademark, it's not a patent.
Yeah, it's a trademark.
Hey, how did it pass? Because weka mawe.
Oh no, it's a conversation that is going on. It's called anaitwa Mbavu Destroyer. He's on a mission to trademark weka mawe so that people stop
Eh.
using.
He can, as a slogan, he can. The problem is when you're looking at weka mawe, like it's weka mawe. These are two Swahili words already. How would you claim protection, like exclusivity on the words weka and mawe? No, you want to tell me I cannot come and say weka mawe just because you protected it. See, I'm saying weka mawe, and I've been using that term for years. I even started using that term before you started using it. So what's the difference? The purpose of attestation is basically to, as me as an advocate, to say that this person, I've looked at this person, and it's true that this person is a party to this contract. That is the purpose of this. And now, when we're looking at the execution of an agreement, those are the pertinent parts that deal with the execution. Without attestation, basically, who is attesting to the parties to this contract? The person who's supposed to be attesting to the parties to this contract is the advocate. Fortunately, we have another wakili here.
Yeah, my question was actually a follow-up after what he said on Weka Mawe. I think so it's kind of the same where we see the footballer Victor Gyökeres. He also trademarked his celebration. But also my question to you will be sideline. Apart from that, is there a way one can bypass either an NDA or an non-compete? Whether if you're looking at, let's say you resign from a company role and maybe you're seeking open roles, but yet there's that limitation where you cannot work for, let's say, your competitor, or maybe there's an offered contract. Is there a legal way you can bypass such a provision?
Whatever, I don't think I should say this when I'm being recorded, so maybe I think let us meet Nyuma tent. I don't think I can say this in front of everyone.
It's okay.
Yeah, but there's a way to bypass it. It's not, Nyuma tent. Kindly. Hi.
So my question is, while back when I was in campus, I once featured on a YouTuber's channel on a certain video, and I've just checked it out. It has like 2.3 million views. So by the time of the recording, I wasn't aware of all this information. Sasa swali yangu ni, is there a way I can make money out of that?
Hakuna. From the start, tulisema you state whatever you want. From the start, state whatever you want. Unaona siku ulikuwa approached.
Yeah.
Ungemwambia you want 30% of your royalties. Whatever you get here, whatever you get as the amount, ungesema. Ukusema, ulisema.
Alinitumia vibaya, sikuwa najua.
Ni ukweli ulitumia vibaya, but now you know. Msikubali hizi vitu hivi, by the way. You, especially for creators, you hold this economy kabisa. The amount of money which passes through your hands too easy. I usually wonder sometimes.
Let's say I know somebody who started something and then somebody took it from him. Can I go and report on his behalf and get the money?
I mean, is he still alive?
No, it's just hypothetical, something like that.
It's hypothetical.
Yeah.
I mean, you're not the creator.
Okay, if you are related by blood, something like that.
The best thing you can do, if you can get agency of whatever they created, you can go and convince them, and then they bequeath all the rights to you. Then go after that person.
Okay.
Like go find some agreement there. Like even find an assignment. The purpose of an assignment is to transfer property from person A to B. So whenever this IP or whatever the idea is transferred to you, you have ownership over it. So now you can go after that person and get the money.
This conversation about agreement, patent ownership, I think it can be, we can talk about it until tomorrow, sindio? Though I believe we can have another workshop. That one will be a workshop there. This one was just a masterclass,
Okay.
where you can have your PPT. We'll talk on that. My name is Brian Okoth. You can call me Buba. I'm a brand strategist, and we as Creative Play Group are on a mission to ensure that 1 million youths, 1 million creators in Africa are able to sustain themselves through creative work. And our startups is in 4 arms. We have the talk show, we have the masterclass, which is our creative book, which we are here right now, and also we have the event arm and also the tech arm. Tech arm, we are building tech solutions to solve the creative tech solutions to improve the creative economy. So we are building the systems in the creative economy. And thank you for being here. And I would love our guest to say a few words. How has she felt being here, and what is that one question she thought she was gonna be asked and you weren't asked, Mercy? You should really say that.
Yeah, it's been nice being here. I'll start with that. I thought someone will ask me how to make money from their creations. Like, how do I commercialize on whatever I have? But it seems the economy is nice for y'all. So, yeah, it's been nice. Hopefully, I'll be back. I love giving founders that sense of like, I can actually do this. And the only way you can do that is giving them the confidence that they're structures. So these structures basically are on the business entity side, on the IP side, on the consumer side, and on the finance side. So once you get that sorted out, you're good to go.
Let's appreciate Mercy. Nice one.